Good afternoon, everyone. Thanks, Mark and Mark, for the lovely introduction. I echo their comments. It's great to see everybody in person and everybody online as well. So, all right, well, Mark kind of alluded to the topic that I'm speaking about today, but we're going to talk about the park doctrine. I don't think it gets enough attention. I don't think it gets kind of the lip service that it deserves. So we're going to go into detail on that today. Just quickly, my name is Amanda Johnston. I'm a managing attorney at Gardner Law. I've been with the firm for about 3 years, and prior to practicing there, I've been in-house in various compliance and regulatory roles at medical device companies. I also teach drug and device law with Mark and one of our other colleagues. We teach drug and device law. So yeah, I split my practice at Gardner between regulatory strategy submission work as well as compliance, anti-fraud compliance program type stuff. All right. So we're going to talk about FDA violations, enforcement mechanisms. We're going to mostly focus on the park doctrine and how it's been used. We're going to look a little bit at the DOJ's perspective, because obviously that's a piece of the puzzle as well. We'll do some predicting on what we'll see from a park doctrine front in the coming future, and then some just recommendations and parting thoughts. And as Mark noted, if anybody has questions, raise your hand. We'll run a microphone to you, and then if you have questions online, we'll monitor those as well. All right, just to ground everybody, I think everybody knows what the Federal Food, Drug, and Cosmetic Act is. But this is the body of law that we're working under. So it was passed in 1938, giving authority to the FDA to essentially oversee the safety of food, drugs, and cosmetics, and medical devices were later added, as well as other categories. The key point is that FDA then implemented regulations, and those regulations dictate how drugs and devices are manufactured and promoted. So there's lots of rules, as I'm sure you all are very familiar with. It's also important to remember that FDA is not a law enforcement agency. They are responsible for protecting the public health. That's their mandate. So they work closely with some of the other law enforcement agencies, but their mission is to protect public health. All right, so we have, the Food, Drug, and Cosmetic Act. We have the FDA regulations. What happens if those FDA regulations are not followed? So there's two primary prohibited acts under the statute: misbranding and adulteration. Just at a high level, of misbranding typically means that something's wrong with the words used to describe or promote the device. So some examples of this would be promoting for unapproved devices, or promoting unapproved uses or features, making false or misleading statements about a product, or not balancing benefits with risks, inadequate directions for use. Adulteration, on the other hand, is more to do with how the device is manufactured, how the product is manufactured. So there could be a rat infestation at a warehouse. It could be a company that has an inadequate quality management system. There could be other manufacturing issues. So just at a high level, these are the two kind of buckets that FDA violations will fall under. So the first one is kind of the words and discussions around a product, and the second one is more around how it's made. All right, we have a poll question. And those of you online, I think there's a poll section that will pop up. So if you could navigate to that. And those in the room, I'll just have you raise your hand. True or false? As an executive, you can be held criminally liable for your employees' misconduct, even if you don't know about the misconduct. Who thinks that's true? Anyone false? Mark gave away, he stole my thunder. Do we have any results online?
Online, there's a 94% agreement that it's true.
Okay, good. Well, that's good. I'm glad that we are all at least aware. All right, so now we'll segue into the park doctrine. So this actually, this whole concept of holding corporate officers liable for acts of the company and their staff actually began back in 1943. The case was US v. Doderweich, I think is that how German colleagues, is that how you say it? I think so. Doderweich. So anyway, Joseph, the president and CEO of a pharmaceutical company. The company essentially had like a private label. They would buy drugs, relabel them. In some of the cases, the labels were incorrect, so they contained either the wrong meds or the wrong amount or the wrong potency. There was an FDA violation, and Doderweich had no knowledge that the drugs that were mislabeled were actually shipped into interstate commerce. And so this went up to the Supreme Court, ended up holding that individuals can be held criminally liable for FDA violation without consciousness of some wrongdoing if they have a responsible relationship to or have a responsible share in the violations. So this was really the kind of landmark case where the concept of a corporate officer being held criminally liable came into play. And we'll look at the statute that they were interpreting. But essentially, responsibility and authority. So they will hold you criminally liable if you have responsibility and authority either to prevent in the first instance or to promptly correct the violation complained of, and if you fail to do so. So this was actually the first case, 1943. And then Park, US v. Park, wasn't until 1975. So Mr. Park was president and CEO of Acme Markets. It was a big national retail food chain. They had 36,000 employees, almost 1,000 locations, so it was a big company. There was an FDA inspection at one of the warehouses. They discovered a rat infestation. It's kind of gross. Acme actually failed to address the problem. So Mr. Park knew of the rat infestation. He delegated responsibility to address the problem down to his direct reports, but the problem was never addressed. So FDA came back, I think 2 more times, inspected. There were still rats. So they were actually Acme, so the company and Mr. Park were both charged with for putting adulterated food into interstate commerce. So again, we're talking about not the labeling, but the manufacturing issues. Acme pled guilty. Park ended up going to trial because he was saying, that's ridiculous. Obviously, I just run the company. I wasn't at the warehouse, that kind of thing. So the Supreme Court ended up saying that Park was properly prosecuted and convicted for the adulteration charge because the Food, Drug, and Cosmetic Act imposes a duty to seek out and remedy violations and a duty to implement measures to prevent violations on responsible corporate officers. So this again, we call it the Park Doctrine, but again, this is kind of really the first time where it's becoming more of a precedent. Liability under the Food, Drug, Cosmetic Act does not require awareness of wrongdoing or conscious fraud. Individuals in positions of authority in businesses that affect the public health, which is key, are held to a strict and rigorous standard of accountability under the Food, Drug, and Cosmetic Act. All right, so strict vicarious criminal liability is kind of scary, honestly, to think about. There's only a few, I don't know if you guys remember from law school, there's only a few areas where this is even a legal doctrine. One of which is possession of wild animals. So if you possess a wild animal, you are strictly vicariously liable. FDCA violations is another. And I think the only other one is engaging in certain extremely hazardous activities, which I'm not sure what that is, but so it goes to show you how seriously, public health is taken. It's a very rare use of a doctrine to hold someone liable when they, had no knowledge. So the Park Doctrine, which it's called, or the Responsible Corporate Officer Doctrine, essentially imposes strict vicarious criminal liability upon responsible corporate officers for misdemeanor FDCA violations. There's no proof of knowledge. You don't have to show negligence even, no intent. You don't need to be involved in it. You don't even need to know about it. The liability attaches just because of your role, or the responsible corporate officer's roles and responsibilities. Kind of crazy. So it's 21 U.S.C. 333A1 is the section of the statute that the court's interpreting here. As you can see, there's no intent, there's no knowledge, there's no involvement requirements. And these are misdemeanors, which is, so, it's not more than 1 year in prison, but that's per offense. So it can add up quickly, I can imagine, and fines as well. All right, so we'll go back to our poll question. Answer is true. All right, so the Park case was, back in the 70s. There was very little use of the Park Doctrine itself, kind of in the last 50 years. I'm going to go over some of the cases since 2007. There's really only been, I think, 16 or 20 cases, and there's some controversy over whether a case is purely a Park Doctrine case or not. But I'll just talk a little bit to give you an idea of kind of how this has evolved. I'll share some cases. So Purdue Pharma. So this one is still in the news. You guys have all probably heard of it, but OxyContin, they were allegedly making misleading and false messages regarding OxyContin, about how it's less addictive, less subject to abuse and diversion, less likely to cause withdrawal. In 2007, so the CEO, the general counsel, and the chief medical officer pled guilty to misdemeanor misbranding violations related to those false statements. In this case, these three executives, there was no evidence that they were involved in or even knew about the misconduct. So they were charged purely under the Park Doctrine based on the fact that they were in a position of control at the time the misconduct occurred. Synthes, this is another kind of popular one that I think a lot of people have heard of. So they had a bone cement product. Allegations were related to off-label promotion and making false statements. In 2009, so the president, the senior vice president, and the director of Reg Affairs and Clin Affairs, which is interesting, pled guilty to misbranding and adulteration misdemeanors. So in this case, the government did present evidence that they knew about and participated in the misconduct. So that's kind of where I'm saying they're a little controversial in that, well, it's not really a Park Doctrine case if they knew about it or participated in it. But I'm still including some of these just to give additional context. I thought that was interesting with the director of Reg Affairs. All right, in 2011, KV Pharmaceuticals. So this was a drug company that had some manufacturing issues that resulted in super potent, oversized morphine pills, which seems like a bad bad issue to have. In 2011, so the CEO was convicted of a misdemeanor misbranding case or charge. In this case, the CEO did not know about it, but the court held that he had the authority and responsibility to prevent and correct FDCA violations. So in this case, he had no clue that they were making giant morphine pills, but yet he's criminally liable. Apothecure, so this is a US v. Osborne case in 2012. So this is a compounding pharmacy. Osborne was the president, director, pharmacist. I think it was a pretty small shop. They again had issues with potency and were selling inconsistent potency products, resulting in 3 deaths. In 2012, he was convicted of misdemeanor misbranding. Again, in this case, Osborne had no knowledge about the issue, but he was responsible for procedures, equipment, and training of employees, and had an obligation to essentially prevent the misbranding, is what the court said. So 2 cases where there was, literally no knowledge, just purely they should have probably done more, is kind of what the court said, based on their position of authority. All right, then we have a couple food cases. Johnston Farms. So in 2013, so this is actually the listeria outbreak with cantaloupe. I still remember this, actually. 2 principals were convicted of a misdemeanor adulteration, so now we're talking about manufacturing issues, based on knowledge of conditions that resulted in contaminated cantaloupe, and there were 33 deaths. So the 2 principals did not know that the cantaloupe was contaminated when it went into interstate commerce, but they did know that they hadn't implemented sufficient procedures around anti-contamination to prevent it. So it's just interesting. Egg case, so salmonella contaminated eggs. This is Quality Egg LLC. So in 2014, executives were convicted of misdemeanor adulteration. Again, in this case, they did not know the eggs were contaminated, but they knew of certain sanitation issues and did not address them. And one of the more recent ones is Indivior. They had a Suboxone film that was used for the treatment of opioid addiction. Some allegations involved misleading claims, encouraging prescriptions that were not clinically warranted. In October 2020, the former CEO was convicted of misdemeanor misbranding based on his role as a corporate executive because he failed to prevent or correct FDCA violations. So again, strict liability, didn't know of it, wasn't involved in the misconduct, but was held liable under the RCO doctrine or the Park Doctrine. So kind of scary to see like some of these cases. What does it mean today for responsible corporate officers? So this isn't really news. This has been how it is all along, but I wanted to take a moment today and talk about kind of what that looks like for the future and kind of where we are in the environment from an enforcement perspective. So it means that as responsible corporate officers, we have following duties. I mean, there's multiple there's a proactive, so we have a duty to seek out and remedy potential violations, and we have a duty to implement measures that will prevent them. So not only do we have to look for and fix things, we have to actually foresee issues and take proactive steps to prevent that from happening. And as depending on how large the company is, I mean, that can be really challenging if it's a big company and there's a lot of layers of management. Just some examples of some things that could rise to the level of RCO liability. So we'll talk about a lot of these later today. Off-label, pre-approval promotion, inadequate instructions for use, product defects, quality issues, manufacturing issues. All right, and we can't talk about holding individuals accountable without talking about the DOJ. Of course, FDA, as I mentioned, their mission is to protect the public health. They're not a law enforcement agency. They're not bringing these cases alone. So we also want to explore the DOJ's perspective because they obviously work with the OIG and FDA when they're prosecuting cases. So just quickly, kind of a summary of the recent history on individual accountability from a DOJ perspective. I'm sure you guys all remember when the Yates memo came out. It was a very hot topic. Essentially, it focused really on individual accountability for corporate wrongdoing. I like this quote: "One of the most effective ways to combat corporate misconduct is by seeking accountability from the individuals who perpetrated the wrongdoing." So here we're talking, in 2015, they're kind of talking more about individuals who perpetrated, so individual accountability. And in October 2021, they issued a memo where they created a corporate crime advisory group within the DOJ. And in September 2022, so just recently, they came out with an update based on the feedback from that group. And again, affirmed really focus on individual and corporate accountability. So the department's first priority in corporate criminal matters is to hold accountable the individuals who commit and profit from corporate crime. So they're clearly looking at individual accountability, and they've made that clear now in the most recent DOJ memo. So predictions. So will we see more of Park RCO enforcement? This is just my prediction. I think we probably will. I think it will be particularly in cases where patients are dead. We have deaths, harm, defective products, egregious, false, misleading messaging. If the company has quality management system problems, a pattern of issues that haven't been addressed, and if the company's compliance program is really ineffective or insufficient. There was a recent editorial in the Journal of American, or the JAMA publication in September 2022. And I don't know if you guys have read it. You should Google it if you have not. I don't know if it's under a paywall. Essentially, it's a few authors that are arguing for increased use of the Park Doctrine, basically because that will promote the doctrine's goal of protecting patients. Basically saying the government's not using it enough and we need to use it to sanction and deter bad acts. So this, together with the DOJ's recent affirmation on focusing on individual accountability and kind of the trickling of Park Doctrine cases we've seen, I do think we probably will see more. We'll see. I mean, we'll have to keep an eye out. I will note that we've seen, last summer, July 2021, the OIG released 3 press releases outlining settlements related to device quality issues. And I think it's interesting because these, to my knowledge, they haven't convicted any of the corporate officers, but they're all related to quality issues, defects, and in each case, there was patient harm. So Alere, in July 2021, they settled almost $40 million under the False Claims Act. The allegations were that they knowingly sold defective blood coagulation monitors that produced inaccurate and unreliable results for some patients due to algorithm defect. To my knowledge, I don't think any of the executives have been charged. It's unclear why. FDA does have a list of factors that they consider, which it's not like rocket science because it aligns with every other criminal, kind of the burden of proof for criminal prosecutions, but perhaps, there's more going on, and I don't know. I'm speculating as to why they wouldn't have gone after executives here, but I think it's interesting. St. Jude, there's a $27 million False Claims Act settlement. This is again related to defective products. This one, there was a recall, and they essentially just said that they failed to disclose it to FDA. They failed to fix it, and it was an issue that resulted in device failure. This one was brought by a patient, which is interesting. Again, to my knowledge, I don't think any of the St. Jude executives have been criminally convicted under Park Doctrine, and I haven't heard of any. Who knows? Maybe that's ongoing. I don't know. Avanos Medical, another one. This one is a little different. It's a criminal misbranding case against the company. They also entered into a deferred prosecution agreement. This one was a little bit more, they actually made false statements to FDA, and they had surgical gowns that were labeled incorrectly, intentionally, it sounded like, allegedly, I should say, with a different protection level than what they actually were. So this is just to remind us that, device quality issues can end up in an OIG settlement, and that together with some of the Park Doctrine, considerations, just kind of will dovetail into the best practices. But just thinking about kind of things that we could do, or, it's hard to prevent a strict vicarious liability criminal charge. But there's some things that we can think about and be proactive about, and just kind of be mindful of as we are hiring and forming companies and starting companies. First of all, I think a compliant and operational quality management system is really essential. I mean, that has to be a top priority. Investing in quality is not something you should skimp on. Conducting internal audits and monitoring is a good idea. Also thinking about the compliance program. So from a healthcare compliance program perspective, maybe consider leadership training on the park doctrine, just so people are, there's awareness. We all know about it, maybe not everybody. Consistently enforcing compliance program violations, so being clear about expectations, and really working on instilling and perpetuating a culture of compliance is probably the best thing to do, although it's harder than it sounds, because you can't really just one day have a culture of compliance. But really kind of embedding that into the company's culture, encouraging raising of concerns and questions. These are kind of things that at least could help mitigate the threat. Making good hiring and promotion decisions. So it sounds easy, another one that sounds easy, but it is something to think about when you're creating a company or making changes in your management team. Establishing clear expectations related to supervisory responsibilities. So in the Park case, Mr. Park delegated to his staff to take care of the rat problem, and it didn't get done. If you're going to delegate tasks, especially ones that relate to product defects and quality system, have a system, making sure it's done, kind of double checking, triple checking, that kind of thing. These are just good practices in general, but might be more beneficial here. Be proactive in identifying and addressing issues, quality, marketing, make sure there's policies and procedures and training in place to make sure that marketing messages, for example, are being vetted and are being used properly. All right. Is that depressing? Does anybody have questions? Do we have any online? Paul, can you get the mic? There's a couple in here.
Hi. Good presentation. Thank you. To remind everybody, I'm curious about the definition of responsible corporate officer.
Yeah.
What is a legal definition of corporate officer?
Yeah. No, that's a really good question, because I looked into that as well when I was creating slides, and I was trying not to go down a rabbit hole. There's not like a specific case that talks about it particularly, but they look at kind of the scope of responsibility. So it's not tied to a title. It's definitely not tied to a title. It is more, do they have authority and responsibility, and did they have authority and responsibility to take the action that they should have taken? So I don't have a definition for you, but it's squishy. But yeah, it's definitely not based on title. So. Oh, okay. See, we all had the same question.
What happens to the chief rat catcher of that company?
Yeah, I know. Maybe they need some cats. That's probably adulterated too. All right. Well, good. Well, thank you very much. If there's no further questions, I will turn it over to Cord.